drafted the 2012 rules, and there were very long and tough debates, especially regarding the ICC emergency arbitration provisions. The starting point was Article 3.1 of the ICC, were the pre-arbitral referee rules. A few members of the Working Commission said we already have an instrument which might grant pre-arbitral relief. We do have the pre-arbitral referee rules. According to these rules, the parties must agree in writing that they shall be applicable. This was the basis, and there was a proposal that these rules shall be made in a way mandatory, that whenever the parties agree on ICC arbitration, they automatically submit to the jurisdiction of this pre-arbitral referee. But others found that, and if the parties want, they always opt out of the jurisdiction of the pre-arbitral referee. But there was criticism, which was that the ICC pre-arbitral referee has very broad powers, and perhaps the parties do not expect the ICC such a system of pre-arbitral interim relief, because the ICC referee does not only have the power to issue any conservatory measure or any measures of restoration, but also the power, and I quote from Article 1 of the referee rules, to order a party to make to any other party or to the other person any payment which may be made. So you can have, it's very practical if you have an ICC arbitral referee. He or she can order provisional payment, which under normal rules of interim relief is very often not possible, because there is a certain rule that the interim order should not in a way anticipate the final decision. But the ICC pre-arbitral referee can do this. And this was the criticism. And the outcome was, as always, a compromise. The result was the emergency arbitrator, which Nadia explained to us in great detail. It has more limited powers than the pre-arbitral referee, but on the other hand, the parties, when agreeing on ICC arbitration, automatically submit to the jurisdiction of the emergency arbitrator. Now, what follows is a short repeat of the jurisdiction. We have Article 6.1 of the rules, which states that whenever parties submit to ICC arbitration, agree that when they conclude an ICC arbitration agreement, they submit to the rule in the version as per the commencement of the proceedings, including the ICC emergency arbitration provisions, with the following exceptions. And just to give you a short background, one is the arbitration agreement must be concluded after the 1st of January 2012, and as Maria already explained, the reason is that we do not want to take the parties by surprise. The next precondition is parties can always agree to opt out, of course, but the opt-out must be expressed. And the parties must not agree to another form of pre-arbitral interim relief, for example, the ICC pre-arbitral referee. And there's another system which you may know, the FIDIC contract for construction. It's a kind of pre-arbitration adjudication, which is a system where parties have to submit the dispute to an adjudicator or a dispute court, and this adjudicator makes a provisional determination, which is not an order, which is not enforceable, but it is a contractual determination, and the parties are bound by this determination and have to comply with this decision. So this ICC also wants to attract states for investment protection disputes. And the states were of the view that we will not accept ICC arbitration for investment protection disputes if an emergency arbitrator can come along and order interim relief against the state. So you see there's still a certain reservation against pre-arbitral relief, and this is why we have this signature requirement. And also because the arbitrator tribunal must assess, the emergency arbitrator must assess whether it has jurisdiction prior to issuing measure of interim protection. And this is rather easy when you have an undersigned arbitration agreement. And this is also the reason why we have this signature requirement. So, we've already seen from Gabriel, this is the ICC 1 arbitration clause, which shows how the ICC would suggest that parties validly opt out. And here we refer to the prerequisites for interim relief under the ICC rules. Daria has already explained to you everything I believe you need to know. I only want to refer to one problem, which is in Article 17a of the Municipal Model Law on Arbitration, we have certain prerequisites, and the language of Article 17a seems to be very explicit and almost mandatory. It says that the party shall satisfy the arbitral tribunal that harm not adequately inherently is likely, and that there is a reasonable possibility that the requesting party will succeed on the merits. So here we have certain prerequisites which appear to be mandatory. The question is, in the ICC rules of arbitration, we have no prerequisites. They simply say, for the purpose of ordering interim relief, there must be urgency to the point that it cannot await the execution of the arbitral tribunal. So this is the greatest possible flexibility. And an arbitral tribunal will have to assess, is it bound by the provisions of the next arbitrary to issue interim relief, for example, by Article 17a. In France, this is a relatively easy exercise because, as we have seen, in France, arbitral tribunals have an enormous power that the French Code of Civil Procedure doesn't say anything about preconditions for interim relief. So this is always an issue when it comes to pre-arbitral interim relief. These are other conditions which you've already heard, and now I come very quickly to my conclusions, which are the following. Perhaps bureaucratically, I would say that state courts and arbitral tribunals are equal. We arbitrators, it is true, we operate under the control of state courts, but we have both our mission, which is to render justice in a definitive way. And it is not that state courts and arbitral tribunals compete with each other. We assist each other. I would submit that we as tribunals, we contribute a lot because we resolve disputes which state courts perhaps do not want to deal with, or which are of a complexity that state courts do not want to deal with. On the other hand, we as arbitral tribunals do need the assistance of state courts. And there may also be a situation where state courts are better equivalently to issue interim relief or interim measures of protection. And one is, and Daria has referred to this situation, she said that the ICC would not administrate emergency arbitration proceedings where the applicant requests that the application shall not be notified to the other side. They would not administrate, I believe, ex parte emergency arbitrator provisions. If you need an ex parte interim order, you have to go to the state court. And the third conclusion, I think,
say, respondent requests the arbitral tribunal to lift the order which was rendered by an emergency operator.
Yeah.
What is the procedure? What does the tribunal do? Does it review the order, or is it an appeal? Or basically, to put it maybe the other way, does the tribunal review the circumstances back then when the order was rendered by the emergency operator, or does it evaluate if the order is needed now, or shall it be kept in force?
They do both. The arbitral tribunal is by no means bound by the decision of the emergency arbitrator. The first thing, of course, it will do when the respondent requests the order to be lifted, it will ask the claimant for comments. And then it will consider whether by the time it was rendered, the order was justified, it must be lifted. But there may also be, and this is often the case, that the circumstances change and that the arbitral tribunal will have to amend the order issued by the emergency arbitrator because of a change of the circumstances, or altogether lift the order. It may be that at the beginning the order is needed and justified, but that subsequently, for example, the respondent can show some kind of security, or the situation may change and suddenly plenty of coal tar is available on the market. Who knows what happens in the world? And then we do not need the provision, the interim order anymore.
And if the tribunal decides that there was no jurisdiction, that the emergency operator had no jurisdiction, but it also decides that on substantial requirements, the order is, the emergency measure is still needed to prevent disposal or whatever, does it have to annul the order and render at the same time?
Interesting question.
Sorry, Christian, may I intervene as well?
Yes, sorry.
Well, so I think, as I said, everything is in the rules. So the answer to your question is in the rules as well. If you look at Article 29(3), so Article 29(3) says the emergency arbitrator's order shall not bind the arbitral tribunal with respect to any question, issue, or dispute determined in the order. So it means that the arbitral tribunal is not it's not the appellate court for the emergency arbitrator, and the emergency arbitrator's order doesn't have the final. You see, it's well. If you look at the nature of the order, for instance, in one of the cases, the emergency arbitrator ordered that the funds should be retained on an escrow account. So you see that it's not a final decision. They're just retained, but for instance, respondent is not deprived of these funds. So if basically at the end the arbitral tribunal review, I don't think that the arbitral tribunal may decide on the jurisdiction of the emergency arbitrator. What the arbitral tribunal can do, it can review the circumstances of the case. The arbitral tribunal has more proof, more elements to decide on the same issues. And if it decides on the same issues differently, so it somehow deprives of the legal force the decision of the emergency arbitrator, and for instance in the situation that I described, the funds will be just released from this escrow account and returned to respondent. Well, sorry to interrupt you, Christian.
No, I think that this is a very important clarification. The arbitral tribunal is no appellate body, but it is not bound by the decision of the emergency arbitrator.
If I could just add my 2 cents. Under Appendix 5, Article 3, which is entitled Challenge of an Emergency Arbitrator, it is for the court to decide on the challenge of the emergency arbitrator. And the challenge must be made within 3 days. So, as as Ms. Shirokova rightly pointed out, everything is in the rule.
So the tribunal cannot decide on the jurisdiction of the emergency operator?
No, the tribunal can decide on the jurisdiction of the emergency arbitrator. And in your case, your case was the situation where the arbitral tribunal would have to find that the emergency arbitrator had in actuality no jurisdiction. And in that situation, I would submit, it will have to lift the order of the emergency arbitrator. But then, the arbitral tribunal itself perhaps has jurisdiction to render the same kind of interim relief as the emergency arbitrator, and it will be allowed to render this interim relief. And then perhaps it would have to lift the order of the emergency arbitrator and issue a new order with the same content. This situation is, I believe, conceivable and possible, and perhaps there's no other solution if the interim relief is needed. Now, what would be your view?
Well, I would say that it, as I said, if I understood correctly, these are two different things: the jurisdiction of the emergency arbitrator and the jurisdiction of the arbitral tribunal itself. You see, so the emergency arbitrator decides on his or her, let's not be sexist, own jurisdiction, and the arbitral tribunal decides on its own jurisdiction. And as for the challenges are not. Challenge is not the question of jurisdiction. Challenge is a question of impartiality and independence of the arbitrators. So basically, what you should distinguish is setting in motion of the arbitral tribunal, whether the arbitral tribunal or emergency arbitrator is impartial and independent, then the admissibility of the claims, and then the jurisdiction. So these are three different issues. For instance, the admissibility of the claims, in the case of emergency arbitrator, it's whether the parties, for instance, whether claimants filed the request for arbitration, because if a claimant didn't file a request for arbitration within 10 days, it means that it becomes inadmissible, you see. But it doesn't influence the jurisdiction of the emergency arbitration. The jurisdiction may be or may not exist, but the admissibility, these are conditions of accepting the application. We should distinguish these issues.
Let's limit coffee break to 5 minutes and allow other 2 questions, if everyone agrees, I hope.
So, yeah. So my question is slightly different from yours, and that's how we can evaluate the urgency, or how we can prove the urgency in the process. So, which circumstances should be taken into account on the case?
Sorry, what's the question? I didn't hear. Sometimes the sound is really bad.
The question was how can the arbitral tribunal evaluate the urgency of the measures?
Could you please use the microphone?
How the urgency measures, the urgency of this measures, how the urgency may be evaluated by the parties in the tribunal in the process. So, which circumstances should be taken into account?
Okay. The rules don't contain any conditions or any definition of urgency, you see. So I think that when deciding on the urgency of the application, the emergency arbitrator should first of all decide which is the law applicable to the emergency arbitration proceedings. And then, if there is a law applicable to the emergency arbitration proceedings, then the emergency arbitrator should look into this law, whether it contains the urgency. But then we should always remember that there's some percentage of appreciation as well of the emergency arbitrator, whether it's urgent or not. For instance, if you have I don't know, steel plates which are not conform to the requirements, and you say that well, if you say if I cannot dispose these plates now, and if the emergency arbitrator doesn't order, it's my own idea. It's not one of the cases which existed. So if, for instance, you say, oh, well, my steel plates, they don't conform, I cannot dispose them, so please order claimant to order respondent to pay for them. Otherwise, I wouldn't be able to continue my activity. I wouldn't be able to produce other plates to sell, and it will, I don't know, it will create the bankruptcy circumstances for me, and I will be bankrupt. So this may be some urgency as well, right? For me, at least.
I may only add that there may be two different kinds of urgency. For example, under Article 28, for the arbitrator interim relief, simple urgency may be enough, but for the pre-arbitral interim relief, we have as prerequisite urgency that cannot await the constitution of the arbitral tribunal. So there may be a situation where you can say that, well, the party needs redress, but it can wait for 2-3 weeks or for 2-3 months, and the arbitral tribunal will be constituted in a few weeks. And then the emergency arbitrator may have to say, yes, there is urgency, but it's not so urgent that this can be executed. Thank you.
Okay, now we have a very last question from this session.
Okay, I actually have two, but they're short ones. I hope that you will deal with them quickly. Do you hear me?
Please use the microphone. I don't hear you.
I have two questions. They're short ones also. First one, I'm curious about statistics. If any data is available so far. How many applications for emergency arbitration proceedings the ICC have so far? If you know how many of such applications were satisfied, and what's probably more interesting, how many of orders were complied with voluntarily?
Well, it's 5 questions instead of 1. First question, how many applications? Up to date, there were 15 applications, which, as I said, I don't know whether you assisted, is a very good figure because we had, as for pre-arbitral our referee proceedings, we had only 14 for 24 years. Now we have 15 for 3 years, right? So it's a good figure. 10, we had 10 applications accepted. And in any event, if you are interested in that, there's a very good article by our General in the ICC Bulletin. I have it with me even. So it's volume 25, number 1, 2014.
Okay.
So there is a short description of the cases which may be interesting. Apparently, if I remember correctly, 8 applications. In 8 applications out of 10, the emergency arbitrator decided that it has jurisdiction, and if I'm not mistaken, 4 of them were granted, 4 of them were not granted. As for the level of enforceability, I don't remember. There is some information in the article, but I don't remember now. So I don't want to give you wrong figures.
Okay, thanks.
In any event, it's public information available for everyone.
Thank you very much, Daria. Thank you very much, Christian. Now we'll have 5 minutes coffee break. I very regret, Daria, you cannot join us personally. but I will help you to do this next year.
Я тоже надеюсь на это. Спасибо всем большое. До свидания.
Exactly.